Yes, so it's great to welcome you back to our random free law revision sessions. And I say random in the sense that I don't have like a very fixed time. I run it according to as and when I get the free time from my schedule or my work timetable. And some of you are probably joining for the first time, and others have also joined before. So the purpose of this session is to help those who are preparing to write the Ghana School of Law entrance examination, to help you to revise that which you are supposed to have learned already when you are doing your Bachelor of Laws degree in the various universities. Again, it is also supposed to help those who are not writing the exams, but they are still pursuing their LLB in the various law faculties, and they need to get some other explanation of things that they have been taught already. And again, it's also supposed to help those who are doing professional law called the POSCOR, those who are lawyers from other jurisdictions, from United Kingdom, Gambia, Sierra Leone, and Nigeria and Rwanda, who need to get a license as lawyers in Ghana, and it's a requirement that they pass Ghana legal system. So just to let you know that my book, which has been on the market since 2019, has been substantially revised, and now it's in 2 volumes. We have volume 1. So volume 1 addresses legal system, and then volume 2 addresses legal method. So, and the other feature which has been added is that for each topic, I have provided questions, revision questions to guide you to measure the progress that you have made as you learn. So once you get copies, probably from next week or 2 going when they'll be out, you'll be able to see the new things and how useful they are in your learning. Okay, so we would like to explore. I think I have to, please put off your mic and put off your voice. We would like to explore sources of law in Ghana. And by sources of law, anytime we mention that, our mind should go to that which enable us to make a determination as whether something is lawful or unlawful, as whether something is legal or illegal. And for that matter, where an assertion is made that something has been done contrary to the law, the presupposition is that there is a law in place which requires things to be done in a particular way, or which forbid or prohibit things from being done in other ways. And that is the usefulness of knowing the sources of law. And as a matter of fact, when you are learning legal system in any part of the world, the most important topic, if we didn't know anything at all in legal system, if we didn't know anything at all, you need to understand sources of law. You need to understand the adjudication structure, that is the core structure. If you didn't know anything at all about the legal system, these are crucial things that you should know. So sources of law are the legal foundation which enable a state to be governed, and they provide the basis for all judicial decisions and legislative actions. So in Ghana, in our textbook, we have decided to classify sources of law into 2 main compartments: primary sources and secondary sources. So by primary sources, we are talking about the binding, sources of law. They are direct, authoritative, legal materials, which form the bedrock of legal enforcement and governance. they have mandatory authority in the sense that they are binding. So we take the Constitution, we state the statutes or Acts of Parliament, judicial decisions from the higher courts, that is the superior courts of judicature, starting from the High Court, the Court of Appeal, the Supreme Court. So these three courts in Ghana, they provide decisions which may constitute judicial precedent or stare decisis, as the case may be. Now, we also have persuasive authority. Persuasive authority in the sense that, yes, they are also sources of law, but they are not binding because they are from other jurisdiction. So, for example, cases decided by the UK Supreme Court and previously the House of Lords, no superior courts in other jurisdiction. They may be very useful, but they are not binding. They only provide inspiration, they provide guidance, so that if there is a problem before a court in Ghana and a similar problem has been resolved or adjudicated in other jurisdiction, the court in Ghana may, for example, draw inspiration from how the court in the other jurisdiction actually adjudicated that matter. And that is why we say that they are persuasive. Now, quite apart from that, it may also have legislation from other countries. Legislation from other countries are not part of our laws. By no stretch of imagination can they be applicable in Ghana. However, they may have some other value or some other uses. That is to say that where the content of the legislation from another country, for example, the content is the same as the legislation that we have in Ghana, then in law, we say that the legislation we have in Ghana is in pari materia, that is of the same, if you like, content, wording and all that, as a legislation you have, let's say, in another jurisdiction. And for that matter, where there has been an interpretation of that legislation, which is in pari materia with the legislation we have in Ghana, should it become necessary for a court in Ghana to interpret the legislation which is in pari materia with that we have been interpreted already in another jurisdiction, the court in Ghana could, for example, draw inspiration, could take the interpretation which will be given in the other jurisdiction as an analogy to guide and help it to arrive at appropriate or suitable interpretation. So let's keep that in mind. So within the context of the understanding that we have given in our book, that we have primary sources of law, and for that matter, the Constitution is the primary source of law in Ghana. Primary source in the sense that it is the Constitution itself which even tells us what the sources of law in Ghana are. And for that matter, if you look at Article 11, Clause 1 of the 1992 Constitution, it has adumbrated, or it has provided the list of what the primary sources of law in Ghana are. And these are the Constitution itself, enactment made by or under the authority of Parliament. So here, we are referring to Acts of Parliament. And then orders, rules, and regulations made by person, authority, and the power conferred by this Constitution. So we are talking also about delegated legislation, or what they call subsidiary legislation. Then we also have the existing law and the common law. Now we are going to take these sources of law one after the other and look at them in a bit more detail. And another thing to note about the second edition of our book is that there has been a very comprehensive treatment of the sources of law in Ghana, as well as the court structure, especially the volume 1 that I have mentioned. So the Constitution, as we have indicated, is a supreme law and forms the basis of all other laws in Ghana. So let's have a bit of a detailed look at the Constitution. And the discussion we are doing everything, we have extracted the points from chapter 3 of the second edition of the book, Ghana Legal System and Legal Method, volume 1. So as I've said, volume 1 is essentially on the legal system. Now, the 1992 Constitution, in a sense, is not only the supreme law of Ghana, but it's also a social contract between the government and then the governed, between the Republic of Ghana and between, the people of Ghana. So let us keep that in mind. And there have been key judicial interpretation by the Supreme Court in landmark cases which oppose the Constitution's authority and application. And if you look at our work, we have provided a lot of that. So I've just extracted few from the chapter 3. So for example, if we take the case of Republic versus the High Court Financial Division 3, Accra, S Party, Michelle's Adjoa Company Limited. Justice Duche, speaking for the Supreme Court, made a dictum, which I quote: pursuant to Chapter 4, Article 11 of the Constitution, which deals with the laws of Ghana, the Constitution 1992 is the grunum, that is to say, the basic law, followed by enactments made by or under the authority of Parliament, established under the Constitution, followed by orders, rules, regulations made by person or authority under a power conferred by this Constitution, the existing law and then the common law in that descending order. Of course, those of you who are familiar with Kerson's theory of law, his pure theory of law, when you talk about the grunum, Hans Kelsen made the point that the legal order could be likened to an inverted collapsible pyramid. And then, so when the pyramid is inverted, that is the apex is down and then the broad base is rather looking up. So the base, when the pyramid is inverted, the base will become like the grunum, and all the norms within the legal order or the hierarchy of that order, they draw their validity or they draw their efficacy from the grunum, also known as the basic norm. And it's the same language which Justice Doche was employing to make the point that the Constitution of Ghana is the most basic, is the most fundamental. It is the grunum, so to speak, of Ghana. Of course, we have also already encountered how, in respect of the 1979 Constitution, in the well-known case of Tufo versus Attorney General, SOA JSC made a similar pronouncement. And that pronouncement has been given judicial blessing in long line of cases. Almost every constitutional law case where there's a serious issue of interpretation, you see reference being made to the dictum of Justice SOA in Tufo versus Attorney General. And what did he say? Quote, "A written constitution such as ours is not an ordinary act of parliament. It embodies the will of a people. It also mirrors their history. Account, therefore, needs to be taken of it as a landmark in the people's search for progress. It contains within it their aspirations and their hopes for a better and a fuller life. It is a fountainhead for the authority which each of the three arms of government possesses and exercises. It is a source of strength. It is a source of power," unquote, and so on, as you notice. Similarly, in the case of the National Media Commission against Attorney General, Accra GSC also made a similar point when he stated, and I quote, We are dealing with our national constitution, 1992, not an ordinary act of parliament. It is a document that expresses our sovereign will and embodies our soul. It creates authorities and vests certain powers in them. It gives certain rights to persons as well as bodies of persons and imposes obligations as much as it confers privileges and powers, unquote. So all these dicta are meant to reinforce the supremacy, the primacy of the 1992 Constitution as a source of law in Ghana. Similarly, in Amidu against President Kufuor, Justice Pega made the observation, quote, "Our constitution, like the American Constitution, is a written constitution underpinned by the doctrine of separation of powers. And it is important to say that being a written constitution, it has, like the American Constitution, certain fundamental or basic attributes," unquote. In the same vein, Accra Hawa again say, with respect to the case of Amidu against President Kufuor, that where it is alleged before the Supreme Court that any organ of government or an institution is acting in violation of a provision of the Constitution, the Supreme Court is in duty bound by Articles 2, Clause 1 and 130, Clause 1 to exercise jurisdiction unless the Constitution has provided a specific remedy, like those of Article 33 and 99, for dealing with that particular violation. It follows, therefore, that no individual, no creature of the Constitution is exempted from the enforcement provision of Article 2 thereof, unquote. So Accra's dictum is another reinforcement of the supremacy of the Constitution as a source of law. A similar point was made in the case of Edusei against Attorney General, and Accra making a similar observation. Well, I mean, we need not quote it, but he made the point that, yes, the Constitution would supersede any other legislation where there is a conflict, as it were. So in discussing the Constitution as a source of law, we need to have a bird's eye view of the constitutional history of Ghana. That is how the Constitution actually evolved. So in our work, that is the Ghana legal system work, we make the point that if you look at the colonial period up to post-colonial period, Ghana has experimented, as part of its constitutional evolution, several constitutions. Well, the current constitution that all of us are too familiar with, thank God, having operated it for the past, over 3 decades, was adopted as a result of democratic consensus. And we'll come to appreciate that very soon. That fateful day in April 1992, after the referendum. So in terms of timelines for our constitutional evolution, we all know that before the colonial period, we had our various ethnic groups and interactions as a result of inter-ethnic fight, conquest, and trade. And yesterday, those who followed the news, you saw how the Asantehene celebrated a silver jubilee. And within the context of that, it gives you an idea of some of the traditional political arrangements which we had before we came into contact with the Westminster model of governance, which has actually crystallized and metamorphosed into the current dispensation that we have. But at least that was a good reminder of our own indigenous arrangement, because we don't have to forget that before we came to have this Westminster model of governance and legal institution, it is not the case that we are completely useless a bunch of people who do not have an idea of legality, who do not have idea of governance. We had our own unique indigenous system. Of course, in terms of history, remember that the traders, the Britons and other Europeans, going back 1474, arrived in the country, and there be so many developments. We've just cut it short because we've gone through like the various from the bond of 1844, when there was an agreement between the Fante chiefs for the British administration to provide protection to them against other ethnic communities like the Ashantis who were attacking them and all that, and how the bond of 1844 would actually evolve gradually to confer some legal legitimacy on the British, and they will be adopting various constitutions. And as you will notice, the various constitutions which evolved were gradually reformed so as to gradually involve the local people in the legislative assemblies. And eventually, when Kwame Nkrumah came into the picture in the 1950s, to also involve the local people into the executive authority and all that. And ultimately, in 1957, we had our independence constitution, so to speak. In 1960, we had our Republican statutes, and 1960, we adopted the unitary Republican constitution. Unitary as opposed to federation. So meaning that the government, the powers of governance are just concentrated in the center. Unlike federation, where you have various constituent units or components, and there's a sharing of power between central government and then the various constituents or component units. That is not the case with respect to Ghana. And you remember that just before independence, the National Liberation Movement, spearheaded by the Bafo Koto and co, had actually agitated for federation with the hope that the people of Ashanti will have had an independence within the independent Ghana. But that one was shut down following the referendum or the plebiscite which was held. And eventually, we had the 1960 Constitution, which established the First Republic, and it conferred wide and far-reaching powers on the president, which eventually led to amendment of the Preventive Detention Act, so as to enable the government of the day to be able to detain those who were seen to be nation wreckers and so on. And you saw how a challenge of that in the infamous case of Ray Bafo Koto and others. The Supreme Court actually made the point that the various declaration which the president makes upon his assumption of office vis-a-vis the constitutional provision were not enforceable legally. They were enforceable through political arrangement, so that if the people didn't like what the president was doing, they could go and vote against him in next election and so on. And you saw how that actually stifled our constitutional development. No wonder 1960, we had 66, we had like the overthrow of the constitutional arrangement, and then the National Liberation Council, being the first military administration, took over the reins of governance. And there was a return to civilian regime with the adoption of the 1969 Constitution, in which we adopted what we call the parliamentary system of governance, as opposed to presidential system we had in 1960. 1960 presidential system, in the sense that we didn't have the prime minister and then the president. We had just a unified monolithic executive. The president was both the head of government and also the ceremonial head of state. But in the 1969 Constitution, that is the Second Republican Constitution, we actually opted for the type of constitution that we had at independence, in which we had the parliamentary system, just like the British system. We have like a prime minister, and then we have like the head of state. So that was it. And the 1969 Constitution, as you know, was short-lived because of overthrow of it by General Champon-led coup, which brought into office the National Redemption Council. And subsequently, there was a palace coup, and we have the Supreme Military Council 1, Supreme Military Council 2, as it were. And all that were halted when a young flight lieutenant called Rawlins and other disgruntled junior officers of Ghana Armed Forces actually decided to do what we call the house cleaning in the famous June 4th uprising of 1979, which led to the overthrow of the Champon regime. And ultimately, there was a return to constitutional governance. So we had like the Third Republic, and that brought Dr. Hilary Liman into office. And of course, that was short-lived. Just few months after that, in 1981, the same military leader, J.J. Rawlins, who had led the June 4th uprising and then the overthrow of the Champon regime and ushering in of the Third Republic, had also taken up arms to overthrow the Third Republic, to overthrow the 1979 Constitution. And that happened on that fateful day, 31st December, as we know very well. So from 1981 to 1992, we had a military administration, the PNDC, Provisional National Defense Council, and it had to succumb to various pressures to return Ghana to constitutional democracy. So as part of that effort, there was the body we call the National Commission for Democracy, which actually went around the country to engage and find out the type of constitution that Ghanaians wanted. And then a body of experts known as Committee of Experts, which was headed by Nana Dr. S.K.B. Asante. Those of you who watched the Joy News over the weekend, you saw that he was interviewed on a program they call like The Sage. So Nana Dr. S.K.B. Asante and team of other experts actually did the research and then the technical paper to make proposals looking at our previous constitution, looking at comparative constitutional lessons from other parts of the world, especially Africa, and make proposals for adoption of a new constitution, which would usher the new governance architecture we wanted as Ghanaians. So that was done. And when the draft was made, they used the draft as the basis for discussion of what we call the Constituent Assembly. So the Constituent Assembly was a gathering of Ghanaians who have been invited by the military regime at the time, PNDC, to come and take part in debates regarding what should go into the new constitution, which was meant to return Ghana to civilian administration. So that was done. But a point to make is that Ghana Bar Association and so many other professional groups criticized the initiative by the then military government because, in their view, the military government had actually included many ordinary people, so to speak, who are not technical or professional oriented. And their fear was that they were going to dilute discussions, and it will actually enable the military regime to get his wishes validated by the Constituent Assembly. So there were a boycott by some of these professional bodies. Ultimately, a draft was made, and then the draft was actually put before people of Ghana for them to approve or reject in what we call a referendum. So a referendum is a special type of election in which there's a proposition put before the electors or the voters. And the proposition usually requires one or two answers, yes or no. So the constitution, which had been drafted, was actually put before Ghanaians on 28th April 1992. Now, a yes vote meant that the constitution will be adopted as the new constitution of Ghana, and that will mark the end of the military regime. A no vote meant that the constitution is rejected and the military regime will have to remain in force until we're able to get another acceptable constitution. So it was a big challenge, like caught between the devil and then the deep blue sea. Ghanaians were fed up with the military regime. They were not also too excited by the constitutional provisions, including the so-called indemnity clause. If you look at the transitional provisions, and those indemnity clause or transitional provisions sought to exonerate, the military regime or the government from any accountability. Should there be a democratic government put in place in future? So, as a compromise, a lot of Ghanaians voted yes, so that could bring an end to the military regime. So that is how we got the 1992 constitution. Despite the fact that it was promulgated after the massive yes vote, it was not to come into force until 7th January 1993, because the idea was that it was supposed to come into force with the inauguration of a newly elected democratic government. So that is why the constitution is called 1992, but in reality, it didn't come into force in 1992. And then the election, which was organized to bring the constitution into force, was not actually organized under the 1992 constitution. So it came into force 7 January 1993, as we know, and that was the story of how we came to have our constitution. Now, in discussing the constitution as a source of law, we should also address enforcement aspect of the constitution. And as we know, when it comes to enforcement, The Supreme Court has got exclusive original jurisdiction. The Supreme Court has got exclusive mandate. So the mandate of the Supreme Court in this regard encompasses ensuring all laws, policies, and government actions comply with the constitutional framework. And that is why Article 2 of the Constitution is quite explicit that if anybody think that anything has been done or omitted to be done, and same is in contravention of the letter and spirit of the Constitution, he or she may go to the Supreme Court and seek declaration to that effect. And if you go to Article 130 of the Constitution, you notice that the Supreme Court has been given an exclusive original jurisdiction. Original jurisdiction simply means that when we say a court has original jurisdiction, that is to say that when there is a case, okay, when there's a cause of action, the court, which we take the court to for the first time, for the case to be heard for the first time, that court is said to have original jurisdiction. Ordinarily speaking, the Supreme Court is supposed to be a final appellate court. So nobody should be able to take cases for the first time to the Supreme Court. However, when it comes to constitutional matters, the Supreme Court has been given original jurisdiction, meaning that you don't need to go to any court first before you go there. You go straight to the Supreme Court. As you can see, it's become so common. The recent anti-LGBT bill and so many other things, how people go to Supreme Court to seek certain interpretation and so on. And of course, it need not to be said that the Supreme Court is the final adjudicator when it comes to interpreting constitutional disputes. There are a lot of landmark rulings as far as enforcement of the Constitution by the Supreme Court is concerned. If you take the case of Amidu, if you take the case of Amidu against President Kufuor, for example, you notice that the decision which affirmed that the actions of government organs must conform or align with the constitutional mandate. And if there is any deviation, the Supreme Court has the enforcement powers to rectify same. And again, in National Media Commission against Attorney General, the same point was highlighted with respect to the limits of governmental powers when it comes to protection of freedom. And then we also have so all these, let me say that all these materials I'm discussing are extracted from chapter 3 of our book. They're extracted from the chapter 3 of that book. So again, we take the New Patriotic Party against the Attorney General, also known as the 31st December case. If you remember that case, where, when the PNDC was in power, 31st December every year was celebrated as a national holiday, and there will be military parades and so on, because the Rawlings had created the impression that 31st December was a revolution in Ghana, which ushered in a new era. And for that matter, it needs to be revered, it needs to be celebrated. And this went on for many years. However, when the 1992 Constitution came into force on 7 January 1993, question which arose was whether it was constitutionally maintainable, sensible, to use public resources to celebrate an activity which overthrew a previous constitutional order. Because the 31st December, a revolution or coup overthrew the 1979 Constitution. So, under a constitutional dispensation, is it reasonable to continue to use the public resources to celebrate such an activity. So that was the crux of the matter as far as NPP against Attorney General, the 3rd December case was concerned. And the Supreme Court was forthright that that was not permissible. And the judges who sat on the case included Francois GSC. And he eloquently remarked that, quote, "We need constantly to remind ourselves that the Constitution in 1992 was born of a consensus which was formally approved in a national referendum. The Constitution 1992 consequently embodies and represents the people's will," unquote. In other cases, which also underscores the Supreme Court exclusive original jurisdiction with respect to enforcement of the Constitution, we can mention the case of Adumwa II against Chum, and also the case of Bimpombuta against the General Legal Council. And of course, the Bimpombuta against the General Legal Council, the Supreme Court was at pains to elaborate on its exclusive jurisdiction, to interpret and enforce the Constitution, and made a clear distinction between the lower court's application of clear constitutional provision and the Supreme Court's role in resolving ambiguities or enforcing constitutional norms. So there has been this confusion, and those of you who do who have done the Ghana School of Law and Examination before, I think about a year or two, if I'm not mistaken, a year or 2 or 3 years ago, there was a question which invited students to actually reflect on the relationship between the Supreme Court and the High Court when it came to enforcement of the Constitution. So there's this issue where a constitutional provision is clear and does not admit of ambiguity or competing interpretation. Must a person go to Supreme Court before same can be enforced, or can it just be enforced at the trial court? There have been 2 schools of thought. The one school of thought is that so long as we don't have rival interpretation and the meaning is clear and unambiguous, any court in which that particular provision arises can go ahead and apply it to the scenario before it. Another school of thought says that no, the Supreme Court is to do everything concerning enforcement of the Constitution. Then enforcement includes interpretation and application. So if there's no interpretation, it's application, we should still go there. And that was why in Bimpombuta against General Legal Council, the point made was quite important. And of course, there have been so many cases later on. Also, Kwarteng against National Media Commission. And the Supreme Court actually made the point that especially when, whether ambiguity or lack of clarity is required for the court to engage in enforcement powers, as I've explained, the court introduced a cautious approach to prevent an overwhelming number of enforcement actions before the court. Because if the court, for example, took the view that so long as the thing is constitutional, it doesn't matter whether interpretation or application, you must go to Supreme Court. You can imagine how the floodgate, how the Supreme Court will be inundated, will be overwhelmed with many cases. And that is why in Osei Kwarteng against National Media Commission, the Supreme Court was quite clear that clarity in constitutional provisions might allow lower courts to enforce them without necessitating Supreme Court intervention. So that was a very good decision, because if that were not so, almost everything can be framed as constitutional, especially so if constitutionality is not only about interpretation, it's also about application. And you can imagine the number of cases which will go to Supreme Court and how the Supreme Court will be overwhelmed with workload. Also, in the case of Emmanuel Noboko against Attorney General, that case sought to make some departure from previous interpretations in Osei-Boateng and stated that the Supreme Court's enforcement jurisdiction is independent and does not require a constitutional provision to be ambiguous, to be enforceable. So here, the Supreme Court seems to be going back on what it has said in Osei-Boateng against National Media Commission. So Supreme Court is trying to say that yes, when it comes to enforcement jurisdiction of the Supreme Court, it is not only where there is ambiguity. That is where we have rival meanings, right? Rival interpretation being proffered before you can say that the Supreme Court's enforcement jurisdiction is actually activated. No. But of course, the Supreme Court seems to be saying, if you read that decision later, that even where there's no ambiguity, in making a determination as whether a particular provision is applicable, in itself will involve some exercise in interpretation, because you need to determine whether a particular factual scenario which has arisen warrants application of a particular provision of the Constitution. So that seems to be the raison d'etat behind the shifting of the goalposts by the Supreme Court in call against Attorney General. Also, the case of Mayo Abelezi against the Attorney General, the Supreme Court seemed to have gone back to Osei-Boateng against National Media Commission and indicated a potential shift back towards the need for ambiguity as a precondition for invoking the Supreme Court's enforcement jurisdiction. So it's very interesting how the Supreme Court has been prevaricating. The pendulum has been swinging here and there when it comes to the rare import and proper operationalization of the enforcement jurisdiction of the Supreme Court. Then we also have the case of James Kwabena Bonfu Jr. against the Attorney General. And in that case too, the Supreme Court emphasized that its power of enforcement of the Constitution does not necessarily depend on the presence of ambiguity in the constitutional provision. So again, going back to Osei-Boateng against National Media Commission. So you notice that the two schools of thought, the Osei-Boateng against National Media Commission seems to be making more impact, because Mayor Abelezi actually seemed to have endorsed it, and then Kwabena Bonfu to the same thing. Now, just before we leave the Constitution as a source of law in Ghana, we need to also appreciate the amendment mechanism of the 1992 Constitution. And in our book, we've made the point that the 1992 Constitution provides a structured and rigorous process for amendments aimed at ensuring stability and a thorough consideration before changes are made. So this rigorous process we are talking about differentiate between entrenched and non-entrenched provisions. So what do you mean by entrenched provisions? We have explained that entrenched provisions are fundamental aspects of the Constitution that require more stringent measures for amendments, and that also reflects the importance to the nation's governance framework. So those provisions which are tagged, entrenched, are quite monumental as far as governance arrangements are concerned. And that is why they are entrenched. Because we've made the point that to amend such entrenched provisions, you need to go through elaborate and laborious processes and procedures. So let's look at the amendment process as far as entrenched provisions are concerned. So first, there must be a proposal. So there must be a bill for amendment, which is put before Council of State for advice. Then there's a Gazette notification, and the Gazette notification must be for about 6 months before it can be introduced on the floor of Parliament. So we see how deliberately the constitutional framers are even slowing down the process. So there should be no haste. And again, there's a requirement also for a referendum. And the referendum must secure yes vote by at least 75% of those who will be voting. And if we take all the voters in Ghana, those eligible voters, that is those who are on the register of voters kept by the Electoral Commission. If you are going to have a referendum on an entrenched provision, we should have 40% of those who are eligible to vote actually voting. Meaning that if the turnout is less than 40%, we will not have met the requirement. And of course, once there has been a favorable referendum outcome, Parliament will pass the bill, which will bring about the amendment, and the President must assent to the bill. Interestingly, this power of presidential assent is being given a new scrutiny in the light of the pending cases before the Supreme Court with respect to the assenting to the anti-LGBT bill and so on. So it's interesting. We are waiting to see whenever the cases will be dealt with, the kind of learning the Supreme Court will provide as far as the scope and the various parameters for this presidential assent is concerned. So what are examples of entrenched provisions? The provisions relating to fundamental human rights and freedoms. So the whole of chapter 5 of the Constitution is an entrenched provision. And then provisions related to the executive, entrenched, the legislature, the judiciary, and also the process of amending the Constitution is an entrenched, meaning that you cannot just change it anyhow. Then we also have the unentrenched provisions, and these are provisions that can be amended with less stringent procedures because relatively they are not too critical to the fundamental structure of the state in terms of the governance architecture. So that is a point we are trying to make in contradistinction from the entrenched provisions. What then does the amendment process of an unentrenched provision consist in? So first, you must have the initial publication, and the proposal will be done twice in the Gazette. And the second publication should occur at least 3 months after the first. Of course, Council of State will come in again, and you go through the usual process for making laws in Parliament. But then, in terms of the parliamentary approval, most ordinary legislation, simple majority of Parliament will suffice. But when it comes to unentrenched provision, the bill must be approved by at least 2/3 of all members of Parliament during the second and then the third readings. So that is a Herculean task. And after that, the president must assent or sign it, as it were. Yeah, so we have discussed or explored the primary source of law in Ghana, and you've paid special attention on the pivotal role of the 1992 Constitution. And from the various judicial dicta, we will appreciate that the Constitution is not just a document, it is a bedrock upon which the entire legal system of Ghana is built. And that is why we have to pay attention to it. The importance of the Constitution, we have seen it, its supremacy, and then we've also understood why it is has got that primacy within the context of various other laws and so on. Yeah, so I'll pause and take one or a few questions before I will end. So next time I will do a presentation on enactments or acts of parliament. Sources of law are a lot, so we do, I think, 4 more sessions and then we'll be done on this.
Okay, good afternoon, Doc.
Good afternoon.
Thank you very much, and we really appreciate this maiden discussion. Please, Doc, I jumped in the middle. I want to find out whether you share the briefs with us on the WhatsApp platform. Thank you.
Yeah, okay, those who are on some of the WhatsApp platforms, yes, I'll put them there. Yes, I'll put them on the platform if you're there.
And then secondly, I want to find out whether the